Hey everybody, the cameraman here. Today I'm here with Kyle Wilde outside of the Butte County Courthouse, and he is the Kyle Wilde in the case of People versus Kyle Wilde here in Butte County. And he'd like to take a moment of your time and discuss some memorandums he filed with the Superior Court. And let me introduce the man himself.
Hey, what's up? How you guys doing? Oh, the camera's this way. What's up? Just kidding. Hey, what's up, y'all? So, Kyle Wilde, and got a bullshit ass charge. You hate me, or you can get on the bandwagon and fight for rights. And that's the whole point of this video. I don't give a about this charge, you understand? Innocent. Innocent, 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 innocent. Okay? I'm being prosecuted with bias. And if you did your research on my case, I guarantee you bias will flare up inside you with a passion. Fuck you for that. But if you care about the Constitution, if you care about combating government, tyranny, dictatorship, and them lying to you all the time and using your ignorance of the law against you to be dictators, then listen up, okay? Otherwise, continue being a dumb slave. Continue being their drones, their putty. Continue being putty in their hands. Because I tell you what, man, we the people have the power in this country, not the government. You understand? The government wants you to think otherwise. And they use the long arm of the law enforcement officers to fearmonger, to beat you down mentally, emotionally, and physically. What's up, Rodney King? To get you to conform to their agenda. It's the other way around. We are supposed to make sure that they conform to our agenda. You understand? They are our agents. They belong to us. They answer to us. Not the other way around. You understand? There's a huge problem in this country with the United States government attacking the Constitution. They are eroding it so that they can destroy it and get rid of it and have absolute power. And it's a clandestine attack. Listen to these memorandums. Listen to everything that I read. You will hear. Okay? You will understand. And if you don't understand, play this shit back and do the research. Don't be lazy. Okay? Laziness is what puts you in your chains in the first place. You let them do it. First memorandum, right of privacy violated. Okay? This is some Edward Snowden type shit. You understand? Taking place right here in California. Okay? Government invasion of privacy. Listen in on your phone calls and everything, right? Commonly called a pretext phone call. These pretext phone calls are highly illegal. Okay? And they're highly illegal because a corrupt ass judge decided he or she was going to implement a decision, a court decision in case law that would allow law enforcement to abridge constitutional rights, to abridge the Fourth Amendment, to abridge the Fifth Amendment, to abridge the 14th Amendment, okay? And invade our privacy wantonly, okay? This incorrect interpretation of a California statute has allowed law enforcement 40 plus years of an attack on our constitutional rights. Okay? They don't want to admit to it. They want to cover these up. They want to hide them. They don't want to answer them. My own attorney doesn't want to fucking touch it. Why? Because they want to fucking keep it the way it is. They want to keep the power that they have. They don't want it stripped from them. No dictator does.
So you're saying that your attorney, even your own attorney that's supposed to be an advocate on your side and fight for your defense, doesn't even want to touch these motions and listen to them?
My attorney, his primary job, okay? A defense attorney isn't like a privately hired attorney, okay? The defense attorney, their main objective is to ensure that the constitutional rights of their client is protected. That is the sole purpose of the public defender. They're not meant to get you off or get you a better deal or anything like that. Their sole purpose is to protect your constitutional rights. Now, my attorney, Eric Ortner, okay, his office is up on Forest Ave up in Chico, California, okay? I filed all these. I've told him repeatedly about constitutional violations, and the dude hasn't read a single fucking page. And then he's told me this, okay? And then he has the audacity to go up into the courtroom and say he doesn't see any constitutional violations on some of the stuff that I filed, but on other things that is going to bear more research. And it's been 6 months since my last court date, and he hasn't fucking done a goddamn thing about reading up on my claims of constitutional rights violations. When you hear these, you're going to agree. You're going to agree that A, I'm going up against my attorney. B, I'm going up against prosecution. And the judge, Christine Lucena, okay, you can dismiss that whole honorable part. That's garbage, okay? She brings bias into everything she does. She wants to silence everybody, okay? She wants to silence everybody. Now the whole thing that these guys got going on is they got a group of people. Okay, when a case comes before them, they're like, okay, we're gonna give him or her this attorney, right? Because we can get a conviction. So they do this cloak and dagger, back alley deals and shit, right? You give me this person, I'll give you this right here, that and the other, right? And the judges are all in on it too. Judges are in on it. We know this. Now listen up. So the first I filed other memorandums, but I'm just going to read the ones pertaining to this pretext call, okay? So just pay attention. Defendant's memorandum regarding right of privacy violated. The legislature hereby declares that advances in science and technology have led to the development of new devices and techniques for the purpose of eavesdropping upon private communications, and that the invasion of privacy resulting from the continued and increasing use of such devices and techniques has created a serious threat to the free exercise of personal liberties and cannot be tolerated in a free and civilized society. The legislature, by this chapter, intends to protect the right of privacy of the people of this state. The legislature just declared its intent in California Penal Code Section 630, titled Declaration of Policy. This 75% portion of Section 630 of the California Invasion of Privacy Act clearly and unambiguously declares the concerns of the legislature and the serious threat electronic surveillance poses to the free exercise of civil liberties, of the right of privacy of the people of this state. It is clear that the spirit of the act, which is meant to always prevail over the letter, is to create privacy protections, violations of which cannot be tolerated in a free and civilized society. Okay. The remaining 25% portion of Section 630 states the legislature recognizes that law enforcement agencies have a legitimate need to employ modern listening devices and techniques in the investigation of criminal conduct and the apprehension of lawbreakers, Therefore, it is not the intent of the legislature to place greater restraints on the use of listening devices and techniques by law enforcement agencies than existed prior to the effective date of this chapter. The intent declared by the legislature was not to place greater restraints. In contrast, the intent was not to provide lesser restraints. An example, the intent was not to prescribe exemptions from the serious threat to the free exercise of civil liberties inherent in electronic surveillance recognized by the legislature. Okay. Now, what we're discussing is Penal Code 630. It's also known as the California Invasion of Privacy Act. All right. And the judge who did this incorrect interpretation that I mentioned earlier interpreted it to mean that there exists exemptions in this act, and specifically in section 633, that exempt law enforcement from any prohibitions in the act. Wrong, and you'll see. It would be absurd for the legislature to recognize a serious threat to personal liberties and prescribe lesser restraint, an example, exemptions, while at the same time declaring that the serious threat to civil liberties cannot be tolerated and said civil liberties shall therefore be protected from said serious threat. The legislature is constitutionally mandated to create statutes that conform to the Bill of Rights, the United States Constitution, and the California State Constitution, and in this regard, the California Supreme Court, in re-application of Haynes, I believe that was a habeas corpus case, 195 California 605, that's March 19th, 1925 case. Held that absurd or unjust results will never be ascribed to the legislature, and it will not be presumed to have used inconsistent provisions as to the same subject in immediate context. See also Wells Fargo and Company versus Mayor, etc. of Jersey City, 207 Federal 878. The subject in both Penal Code Sections 632 and 633 pertains to electronic surveillance and the scope of authority delegated by the Act to persons defined therein. Penal Code Section 632B, as in boy, defines person as, for the purposes of this section, person means an individual acting or purporting to act for or on behalf of any government or subdivision thereof, whether federal, state, or local. Now, if you're unfamiliar with the California Invasion of Privacy Act, pay attention to that last part. Okay. The persons described in Penal Code Section 633 describe the same persons defined in Section 632B. California Penal Code Section 633 reads, the Attorney General, any district attorney, or any assistant, deputy, or investigator of the Attorney General, or any investigator of the Attorney General, or any district attorney, any officer of the California Highway Patrol, any peace officer of the Office of Internal Affairs of the Department of Corrections and Rehabilitation, any chief of police, assistant chief of police, or police officer of a city or city and county, any sheriff, undersheriff, or deputy sheriff regularly employed and paid in that capacity by a county, police officer of the County of Los Angeles, or any person acting pursuant to the direction of one of these law enforcement officers. It is noteworthy that the above listed persons are considered federal, state, or local manifestations of the government they act for or on behalf of, respectively. So these guys right here, listed in Penal Code Section 633, are persons defined in Section 632B. Okay? It is apparent by the plain language of Section 632B that the legislature intended to include the very same individuals acting for the government described in Section 633. Therefore, an interpretation of Section 633 exempting or excluding the persons described therein is opposed to the legislative intent of inclusion of the very same persons defined in Section 632B. Okay? The court in People v. Chavez, is that judge, 44 California, 4th Division, 1144, held the criminal provisions of Section 632, which prescribe eavesdropping and interception without the consent of all parties to the communication, do not apply to law enforcement. See also People v. Conklin, 12 California, 3rd District, 259. Uh-oh, there's another judge who did the same thing. Penal Code Section 633 of the Invasion of Privacy Act, which is Penal Code Section 630 et sec, which exempts law enforcement from the Act's general prohibition against electronic eavesdropping, hold law enforcement to the electronic surveillance prohibitions enforced prior to the effective date of the Act. That's a far cry from exemptions. The above interpretation of exemption is incorrect, okay? And the electronic surveillance prohibition in force is the Act itself. The interpretation that Section 633 exempts law enforcement creates an inconsistency between provisions as shown herein. With the Act's definition of person, the interpretation of law enforcement exclusion, Section 633, is inconsistent with the prescribed law enforcement inclusion, Section 632B. And as per the Supreme Court of California, in the case Henry Haynes Supra, this inconsistency between provisions shall not be ascribed to the legislature. Therefore, as prescribed in Henry Haynes Supra, some other sufficiently flexible construction of Section 633 must be adopted that harmonizes with the Act's other expressed provisions as to the same subject. Protection against a serious threat of invasion of privacy in California by persons defined in the Act. Okay? To harmonize the provisions of Section 632B and Section 633, statutory language must be construed in the context of the statutory framework as a whole, keeping in mind the policies and purposes of the statute. People v. Chavez. See also West Pico Furniture Company versus Pacific Finance Loans, 2 California 3rd District 594, and Rudd versus California Casualty General Insurance Company, 219 California Appeals 3rd District 948. And to do this, the Supreme Court of California in the Henry Haynes case prescribed on March 19, 1925, statutory construction requirements. The mere literal construction of a section in a statute ought not to prevail if it is opposed to the intention of the legislature apparent by the statute, and if the words are sufficiently flexible enough to admit some other construction, it is to be adopted to effectuate that intention. The intent prevails over the letter, and the letter will, if possible, be so read as to conform to the spirit of the Act. While the intention of the legislature must be ascertained from the words used to express it, the manifest reason and obvious purpose of the law should not be sacrificed to a literal interpretation of such words. Words or clauses may be enlarged or restricted to effectuate the intention or to harmonize them with other expressed provisions. Where general language construed in a broad sense would lead to absurdity, it may be restrained. The particular inquiry is not what is the abstract force of words or what they may comprehend, but in what sense they were intended to be used as they are found in the Act. Henry Haynes Supra, quoting Lewis Sutherland on Statutory Construction, 2nd edition, section 376, page 721. First of all, the word exempt, nor any of its other spellings, exists in Penal Code Section 633. And in fact, I don't believe the word exempt exists in the entire act. Second, California Penal Code Section 633 provides that nothing in California Penal Code Section 632 shall be construed as prohibiting any police officer or any person acting pursuant to the direction of such officer, acting within the scope of his or her authority, and I add this last part, as prescribed by the harmonized and consistent statutory framework as a whole. So statutes, okay, statutes provide the scope of authority to law enforcement, to judges, to prosecutors, you know what I mean, to government officials. A statute prescribes the scope of authority, okay? And that comes down to the situation, okay? Let's say they're going to invade somebody's privacy, okay? Well, they got to look at the statutes that cover invasion of privacy to find their scope of authority, okay? And where they do that is they look at the statutes. And then you have all these judges who make interpretations and stuff. That doesn't mean they've made a correct interpretation, okay? It just takes somebody with a better brain to correct them, okay? So the scope of authority is outlined in the California Invasion of Privacy Act, okay? Law enforcement are bound by that scope of authority. They can't go beyond it, because if they go beyond it, they will need something such as exigent circumstances to do so. You understand? But the scope of authority must be, as I said, acting within the scope of his or her authority as prescribed by the harmonized and consistent statutory framework as a whole. Okay, you got section 632B that includes every government official, right? And you got section 633, which lays out a list of government officials, okay? 632B is defining person for purposes of that section, meaning 632 starts out something to the effect of if any person knowingly or intentionally eavesdrops upon confidential communication without the consent of all parties, you know, then there's punishment and things like that. So we have that in the beginning of section 632 section, okay, the first paragraph, and then it goes down to the next one and says, okay, now we're defining person and we're including all government officials. And then you got 633, okay, which includes the same people that are in section 632B, government officials, okay. Now, according to the California Supreme Court and statutory construction, you know, the interpretation that 633 provides an exemption to the people listed there, the government officials, is incorrect because it's inconsistent with the statutory framework as a whole, which means the provision in section 632B of inclusion is inconsistent with the interpretation of exemption in 633 of these same government officials. You see where I'm going? All right. Finally, California Penal Code Section 632 does not prescribe an absolute prohibition on the persons described in Section 632B and 633. Instead, Section 632 delegates to all the parties of a confidential communication the power to prohibit the invasion of their subjective privacy. And in this regard, Section 632 itself does not prohibit persons acting within the scope of his or her authority prescribed by the section from overhearing or recording any communication that they could lawfully overhear or record prior to the effective date of the chapter. Okay. The legislature delegated power through this act to the people of this state, so they would have more authority to control the free exercise of their liberties and the right of privacy. In this way, the legislature placed no greater or lesser restraint on law enforcement than that imposed by U.S. citizens freely exercising their civil rights. Okay? The legislature gave the people of this state the power in which to address the serious threat electronic surveillance poses, which cannot be tolerated in a free and civilized society, and impose criminal punishment for the persons who intentionally violate this free exercise of civil liberties. See also Title 18, United States Code, Section 241, which we'll get into next. The legislature hereby declares that advances in science and technology have led to the development of new devices and techniques for the purpose of eavesdropping upon private communications, and that the invasion of privacy resulting from the continued and increasing use of such devices and techniques has created a serious threat to the free exercise of personal liberties and cannot be tolerated in a free and civilized society. The legislature by this chapter intends to protect the right of privacy of the people of this state. Penal Code Section 630. As the foregoing has shown, an interpretation of exemption in Section 633 is opposed to the spirit of the Act and to the intention of inclusion of those who act for or on behalf of the government prescribed in Section 632B. Therefore, to harmonize the provisions of the two sections in a manner consistent with the statutory framework as a whole, the provisions of Section 633 must be read in light of the Section 632 requirement that a person acting for or on behalf of any government, whether federal, state, or local, must have the freely exercised consent of all parties of a subjective confidential communication. Section 632's prescribed scope of authority, as found in the Act, establishes the scope of authority of the persons described in Section 633, and it unambiguously harmonized the consistent interpretation of Section 633 would then read thus: persons acting for or on behalf of the government described herein may overhear or record any subjective confidential communication with the freely exercised consent of all parties to the subjective confidential communication, and any person acting pursuant to the direction of one of these government agents who has the freely exercised consent of all parties to a subjective confidential communication may overhear or record such communication, and to intentionally do otherwise is punishable by a fine or imprisonment. The proceeding is a sufficiently flexible construction that harmonizes the other expressed provisions of the Act with the language of Penal Code Section 633 and effectuates the intention of the legislature to delegate the scope of authority via the Act in a manner that protects the right of privacy of the people of this state from the serious threat electronic surveillance poses to the free exercise of personal liberties. Now, Black's Law Dictionary defines scope of authority as agency, the range of reasonable power that an agent has been delegated or might foreseeably be delegated in carrying out the principal's business. Okay? Pay attention. Law enforcement officers are the agents of the legislature, while the legislature is the principal who delegates powers through statutes in order to carry out the business of law enforcement and the protection of constitutional rights. As pertains to subjective confidential communication, A. California Penal Code Section 632C defines confidential communication as any communication carried on in circumstances as may reasonably indicate that any, emphasis added, party to the communication desires it to be confined to the parties thereto. The emphasis was added to distinguish the singular any party from the collective all parties used in the first paragraph of the section, as the right of privacy is a personal right. B. Black's Law Dictionary defines subjective as 1. Based on an individual's perceptions, feelings, or intentions, as opposed to externally verifiable phenomena. 2. Personal, individual. Penal Code Section 632C must be read in light of the preceding A and B definitions, which means confidential communication defined in Section 632C is a subjective confidential communication. To support this interpretation, the California Court of Appeal in People v. Santos, 26 California Appeals 3rd District 397, held that electronic surveillance does not constitute an unwarranted invasion of privacy when there is no subjective expectation that the monitored conversation will be private. See also North v. Superior Court of Riverside County, 8 California 3rd District 301. The Supreme Court of California stated in the North v. Superior case, one appropriate test for determining the validity of a particular search for verbal evidence and seizure of verbal utterances, those were added, made without the prior issuance of a warrant is whether the defendant had exhibited a reasonable expectation of privacy, and if so, whether that expectation was violated by an unreasonable governmental intrusion. See also People v. Bradley, 1 California 3rd District 80. People v. Edwards, 71 California 2nd District 1096. The foregoing principle was adopted from language in Katz v. United States, 389 U.S. 347. The Supreme Court of the United States, SCOTUS, stated in the Katz v. U.S. case, where a person knowingly, emphasis added, exposes to the public is not a subject of Fourth Amendment protection, but what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. By the way, me putting all this on blast, putting it out in the public arena, allows these prosecutors to say that, hey, I'm making this an issue. Let's make it an issue, okay? You're gonna lose. See also North v. Superior Court, Supra, People v. Blair, 2 California Appeals 3rd District 249. People v. Stadnick, 207 California Appeals 2nd District 767. The three preceding controlling courts, California Court of Appeal, Supreme Court of California, and SCOTUS, address subjective privacy. In the case at bar, defendant Wilde asserts herein that he was alone in his personal automobile driving approximately 70 miles per hour on California northbound Interstate 5 when Butte County Sheriff's Office agent or agents warrantlessly provoked, eavesdropped upon, and recorded his subjective confidential communication with his cousin Amanda Garrett. Defendant Wilde was unaware government agents were eavesdropping upon and intercepting his wired communication and did not provide freely expressed consent to such activity. Now, cell phones fall under the definition of wire communication, FYI. It is unquestionable that the conditions asserted herein by defendant are defined as a subjective expectation of privacy and meet the prescribed conditions of Section 632 of the California Invasion of Privacy Act. The Butte County Sheriff's Office agents, a non-party to defendant's subjective confidential communication, who intentionally did not obtain defendant's consent and intentionally ensured defendant was unaware of the warrantless electronic eavesdrop and intercept, violated California Penal Code Section 632, thereby engaging in activity that was not only a serious threat to the free exercise of the defendant's personal liberties, but violated those personal liberties, thus committing a criminal offense pursuant to Section 632. See also the incorporated herein and attached here to defendant's memorandum regarding judicial constitutional obligations, which I'll read next. And defendant's memorandum regarding probative liberty chilled. I'm not going to read that one. For additional criminal offenses committed by Butte County Sheriff's Office under Title 18 United States Code, Section 241. Now you guys should look up Monell versus Department of Social Services 436 US 658 and Owens versus City of Independence 445 US 622 and Maine versus Thibodeau 448 US 1 and Title 42 United States Code Section 1983. Look them up because there's other litigation applicable to the constitutional questions regarding the current interpretation issue of Section 633 discussed herein. And what those cases do is they state that qualified immunity, which police have, they don't have quasi or even absolute immunity. They have qualified immunity, and they only qualify for immunity as long as they're not committing a crime or violating the constitutional rights of the U.S. citizen. Okay, what these cases do is take away that qualified immunity. So when you're doing a lawsuit for like a constitutional violation, you want to quote these cases that I just read, because it will tell the court that you're stating you have the authority to remove their qualified immunity, which leaves them liable for suit. You understand? To be sued. And they're not impenetrable. They're not indestructible. You understand? The applicability of Marbury versus Madison, 1 Cranch 137, and Norton versus Shelby County, 118 U.S. 425, to the constitutional questions raised herein should also be considered. And what those two cases say in short is that any law that was ever passed that abridges the constitutional rights of the U.S. citizen is void of all law from the date of its inception and requires no obligation to obey. Statements in the police report for the case at bar corroborate defendant's assertion that he was driving northbound. Wilde was en route back to Washington in a dark blue Chrysler 300, plates unknown. Okay, that's the a detective that's the probable cause or police report author, and they're the cops saying it. And the transcript of the intercepted communications provide corroboration. I'm on the road, line 235. I'm in the mountains, line 371. And I'm just driving, line 629. These were uttered by defendant Wilde. I was just entering the mountains when I got the phone call going up here on I-5. As relates to defendant's assertion of subjective expectation of privacy, the foregoing is a sufficient showing in accordance with the controlling court's holdings pertaining to the expectation of privacy. It was held in United States versus McKinnon, 721 Federal 2nd District 19, that the provisions of the California Privacy Act, Invasion of Privacy Act, concerning tape recording a telephone conversation, Penal Code Sections 631 and 632, cannot be less protective than those of the Federal Omnibus Crime Control and Safe Street Act, Title 18, United States Code, Section 2510 at sec. See also People versus Otto, OTTO. 2 California 4th Division or 4th District 1088. Now, violation of Title 18 USC Section 2510 et sec, that's ET space SEQ, and what that means is just everything attached to that whole title. Title 3 would constitute an unreasonable governmental intrusion as described by the Supreme Court of California in the above North versus Superior Court super case. As these laws were in force prior to February 3rd, 2020, the day defendant Wilde's subjective confidential communication was eavesdropped upon and intercepted, they are therefore applicable to the case at bar. Section 2516 subsection 2 of Title 3 requires authorization or approval by a judge be acquired prior to eavesdropping upon and or intercepting any wire, oral, or electronic communication. As Section 2515 prohibits the use of any intercepted communication obtained in violation of Title 3 from being received in any court proceeding in any state. Even a summary and a probable cause report that goes before a magistrate or gets included in documents for extradition or whatever, you know what I mean, can't be used. Okay. Now, with those two cases that just said, California Invasion of Privacy Act cannot be less protective than Title 3, Section 2510 et sec. And now 2516.2 of Title 3 says that it requires authorization or approval by a judge be acquired prior to eavesdropping upon and or intercepting any wire, oral, or electronic communication. Because the California Privacy Act cannot be less protective than Title 3, Penal Code Section 630 et sec requires a similar warrant and punishment procedure that was not followed in the case at bar. As a result of the violation of Title 3, all derivative use of the defendant's interpreted communication tainted arrest warrant and extradition proceedings in California State and Washington State, respectively. Okay. Now, hey, they tried to call me a fugitive, okay? I ain't no fucking fugitive. I had an out-of-state travel permit to come down here to California, you understand? And I was supposed to go back on the date that all this bullshit went down. And that's exactly what I did. I obeyed the law, and I went back to Washington like I was commanded to do. So yeah, even when you're obeying the law, you're still a criminal. Hey, go figure out. This created a violation of the defendant's right of due process of law and a violation separate from the California Privacy Act. See also Narden versus United States. I'm just tired of this wind blowing this paper around. See also Narden versus United States, 308 U.S. 338. Silverthorne Lumber Company versus United States, 251 U.S. 385. The essence of a provision forbidding the acquisition of evidence in a certain way is that not merely evidence so acquired shall not be used before a court, but that it shall not be used at all. Of course, this does not mean that the facts thus obtained become sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others, but the knowledge gained by the government's own wrong cannot be used by it simply because it is used derivatively. Now, whenever a case law has U.S. between the two numbers, that means it's a U.S. Supreme Court case. Highest court in the land. Because Butte County Sheriff's agents recorded defendant's subjective confidential communication and not Amanda Garrett, the only other party to the communication, just me and Amanda, and because the Butte County Sheriff's agents used a recording device that belonged to the Butte County Sheriff's Office and did not belong to Amanda Garrett, California Penal Code Section 633.5 is inoperative in the case at bar, as Butte County Sheriff's Office agents were a non-party to the communication doing the actual recording with a device that did not legally belong to either party. Defendant Wilde and Amanda Garrett. Section 633.5 provides that a party, emphasis added, to a confidential communication is not prohibited from recording the communication for the purpose of collecting evidence of crime. Okay? If incriminating evidence is secured by means of trickery, subterfuge, trespass, or fraud, and after it has been so secured, finds its way into the hands of governmental officials, no legal grounds can be urged against this introduction in evidence for the reason that no constitutional questions are involved. If, however, the fraud, subterfuge, trespass, or theft is perpetrated by government officials, or if a government official participates directly or indirectly therein, the evidence thus secured is not admissible for the reason that it was secured in a manner which violates the provisions of the Fourth and Fifth Amendments. Byers versus United States 273 U.S. 28, United States versus Mandel 17 Federal 2nd District 270, and Rudkin J. dissenting in Olmstead versus United States 277 U.S. 438. Now, lines 348 through 365 of the transcript of the intercepted communication are Butte County Sheriff's Office agents engaged in an indirect functional equivalent of governmental interrogation being conducted via subterfuge and fraud, which is evidenced by line 643. Now, private conduct. Okay, so what happened was from the narrative, and when I got into the mountains, I lost service. I couldn't hear them, but the connection was still going, or they were still recording, one of the two, right? And so I'm just sitting there listening to a silent phone, and then all of a sudden I hear my cousin Amanda saying hello, 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 right? But what had happened was, or maybe they did get a phone call. That little detail is a little vague. I can't remember. But what happened was is these guys were providing questions to Amanda to ask, right? So nothing, absolutely nothing in the California Invasion of Privacy Act says that they can ask questions while they're eavesdropping or intercepting a confidential communication. There is no language in there whatsoever that says they can do that. Okay? None. That puts it in a gray area. However, you could argue that because the statute says that with the consent of all parties, they can electronically eavesdrop and intercept, and that is it. They can only eavesdrop and intercept the communication, but they cannot use it as a functional equivalent of governmental interrogation or questioning. Alright? They can only eavesdrop and intercept. They can't use it to interrogate through a third party. There's nothing in the act that says they can do that. Nothing. But what they do is they get somebody to call a suspect, right? And either put it on speakerphone or, you know, eavesdrop or intercept some other way. Sit by quietly and write down questions for the other party that's calling the suspect to ask, right? While they're recording. This is how they do that. This is what a pretext call is. But on lines 348 through 365, it recorded them telling Amanda, okay, ask him this, get him to say this, do this, right? So lines 348 through 365 of the transcript of the intercepted communication are Butte County Sheriff's Office agents engaged in an indirect functional equivalent of governmental interrogation, being conducted via subterfuge and fraud, which is evidenced by line 643, excuse me. Private conduct abridging individual rights does no violence to the 14th Amendment unless to some significant extent state in any of its manifestations has been found to have become involved in it. Burton versus Wilmington Parking Authority, 365 U.S. 715. Turner versus City of Memphis, 369 U.S. 350. And when the state has commanded a particular result, it has saved to itself the power to determine that result, and thereby to a significant extent has become involved in it, and in fact has removed that decision from the sphere of private choice. Peterson versus City of Greenville, 373 U.S. 244. The police and probable cause reports in the case at bar show the significant extent that the manifestation of the state of California became involved, and as Butte County Sheriff's Office made the recording with a recording device that belonged to them and saved that recording for itself, there is no private conduct abridging the 14th Amendment rights of defendant Wilde, but rather state conduct abridging those rights and other rights of the defendant. As Judge Rudkin said in Olmsted Supra, those who use the telephone are not broadcasting to the world. Okay, smoke break. What's up? Here's the next, Kyle Wilde, here's the next memorandum. You ready? Judicial constitutional obligations. Okay, defendant's memorandum regarding judicial constitutional obligations. Okay. A judge should be mindful that his or her duty is the application of general law to particular instances, that ours is a government of law and not men, and that he violates his duty as a minister of justice under such a system if he seeks to do what he may personally consider substantial, he or she may personally consider substantial justice in a particular case and disregards the general law as he or she knows it to be binding on him or her. Such action may become a precedent, unsettling accepted principles, and may have detrimental consequences beyond the immediate controversy. He or she should administer his or her office with due regard to the integrity of the system of the law itself, remembering that he or she is not a depository of arbitrary power, but a judge under the sanction of law. That is the canon of judicial ethics, number 20. Influence of decisions upon the development of the law. The law does not tolerate one person, particularly a law enforcement officer, generating in the mind of another person who is innocent of any criminal purpose the original intent to commit a crime. See herein Title 18 USC United States Code, Section 241. Hold on, I gotta light my cancer stick. Thus inducing such person to commit a crime which he would not have committed or even contemplated but for such inducement. That is California Jury Instructions Code number 851 revised. See People versus Moran, M-O-R-A-N, 1 California 3rd District 755. Okay. The courts have created the defense of entrapment as a control on illegal police conduct out of regard for the court's own dignity, and in the exercise of its power and the performance of its duty to formulate and apply proper standards for judicial enforcement of the criminal law. People versus Benford, 5-3, California 2nd District, 1-5. See People versus Moran, Supra. That's where you can find it. A defendant's burden to prove entrapment is not subject to California Penal Code 1096. People versus Moran. My cigarette, we're going to talk. Talk. Love my cigarette. A pretext call is, by its very nature, a trap phone call from a victim or victim's parent, guardian, or a witness to the suspect, wherein the police record the call and the victim is coached by the police into trying to get the suspect to confess or apologize to the victim for certain conduct. The police usually orchestrate and provoke the call, and the suspect is unaware that the police are listening to the conversation, utilizing a functional equivalent of governmental interrogation outside constitutional and Miranda safeguards, including trick questions for the victim to ask. Now, police may believe the victim, but as a part of their due diligence in investigating the claim, they need corroboration from the suspect, especially when the claim lacks corroborative evidence before recommending prosecution, so they use a pretext call. The Fourth Amendment forbids arbitrary governmental invasion of privacy, requiring a search and seizure warrant supported by an affidavit of probable cause prior to its issue, where the amendment's exemption criteria are not met. The Fourth Amendment extends to electronic eavesdropping and recording oral statements. That's Katz v. United States, 389 U.S. 347, Silverman v. United States, 365 U.S. 505, and United States v. Stone, 232 Federal 396. The Fifth Amendment and its self-incrimination clause, and I never self-incriminated, enables the accused citizen to create a zone of privacy which the government may not force him to surrender to his detriment. That's Osborne versus United States, 385 U.S. 323, and we're going to discuss Osborne next in the next memorandum. And that's also the U.S. Constitution, Fifth Amendment. Law enforcement are bound by the law to notify the suspect of his Miranda rights prior to questioning or interrogation, which notify the suspect of the right to remain silent and the right to the appointment of an attorney, also protected under the Sixth Amendment. Law enforcement are bound thus under the Due Process Clause of the 14th Amendment. The pretext or trap call constitutes a compulsory extortion through subterfuge, trickery, and fraud. See also Byers v. United States, 273 U.S. 28, United States versus Mandel, 17 Federal 270, Rudkin J. dissenting in Olmstead versus United States, 277 U.S. 438. In violation of the Constitution, creating a trespass, invasion of privacy, deprivation of the due process of the law, and the right against extorted self-incrimination. This injury of constitutional rights or privileges occurs when law enforcement induce in the mind of the victim, victim's parents, guardian, or the witness to knowingly and willingly agree to the subterfuge, trickery, trespass, and fraud of lulling the suspect into believing the call is private, when in fact the police are directly engaged in surreptitious overhearing and recording the conversation and indirectly interrogating or questioning the suspect by coaching and or providing questions for the victim to ask the suspect. This effectively makes the victim and police conspirators in the action of entrapping the suspect so he admits to a crime. At the same time, it effectively creates a conspiracy between the victim and police to injure the suspect's enjoyment and free exercise of the constitutional right or privilege against self-incrimination outside due process of the law during a warrantless invasion of privacy to search for and seize verbal evidence. Okay, when I say self-incrimination, I mean the right to remain silent and not provide any testimony whatsoever, whether it's incriminating or not. Okay. See also Wong-Sun versus United States 371 U.S. 471. And this falls within the condemnation of Boyd versus U.S. 116 U.S. 616. While specific intent to interfere with federally protected rights must be shown, it is not necessary that offender or offenders be shown to have legalistic appreciation of federally protected nature of right or rights. That's U.S. versus Red Wine, 715, Federal 2nd District, 315. Basically, if they did a pretext call on you, and they put it in the probable cause report saying that they did, that's specific intent to do such a thing, okay? Now, they don't have to know that they're violating your rights. It just has to be violated, period, which it does. Here's section 241. If two or more persons conspire to injure any person in any state in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, they shall be fined under this title or imprisoned not more than 10 years or both. Title 18, United States Code, Section 241. Summarized. It is the duty of all judges in the United States to support the federal Constitution and that of the state whose laws they administer. In so doing, they should fearlessly observe and apply fundamental limitations and guarantees. That is the canon of judicial ethics, number 3, constitutional obligations. The courts refuse to enable officers of the law to consummate illegal or unjust schemes designed to foster rather than prevent and detect crime. People versus Benford Supra. People versus Moran Supra. The Federal Civil Rights Statute, Title 18, USC Section 241, makes conspiracy to interfere with citizens' right or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States a criminal offense. U.S. versus Price, 383, U.S. 787. And conspiracy under Section 241 requires no proof of overt act, since to require one would unduly narrow application of statute. U.S. versus Skillman, 922, Federal 2nd District, 1370. U.S. versus Morado, 454, Federal 2nd District, 167. U.S. versus Whitney, 229, Federal 3rd District, 1296. The pretext call fosters such illegality, and if the crime was suggested by another person for the purpose of entrapping and causing the arrest of the accused if the intent originated in the mind of a law enforcement officer. Entrapment is established according to the United States Supreme Court test. Trainer, CJ, dissenting in People v. Moran Supra, citing Sherman v. United States 356 U.S. 369. Sorrells, S-O-R-R-E-L-L-S versus United States 287 U.S. 435, and this falls within the condemnation of Title 18 U.S.C. Section 241. Title 18 U.S.C. Section 241 must be accorded sweep as broad as its language. This language includes rights under Due Process Clause of 14th Amendment, as U.S. versus Price, Supra. By the way, Supra is Latin for above. So the above quoted Penn site or case law site. The following is Title 18 U.S.C. Section 241 linguistically expanded with Black's Law Dictionary definitions used in place of the singular English words conspire and injure. These English words and their definitions are enforceably protected against diminishment under California Constitution Article 3, Section 6, and includes incorporated and referenced documents pertaining to the constitutional rights involved in the case at bar. Here you go. If two or more persons agree to commit any offense punishable by law, innocent in itself but becomes unlawful when done by the concerted effort of the conspirators, to violate the legal right of any person in any state in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States. Here you see incorporated defendants' memorandums, the Fourth Amendment embodied in the local statute, and unlawful activity in law enforcement officers. They shall be fined under this title or imprisoned not more than 10 years or both. Specific intent required to violate Title 18 U.S.C. Section 241 is purpose of conspirators to commit acts which deprive citizens of interests which are in fact protected by clearly defined constitutional rights, and if that person is present, there is no good. If that purpose is present, there is no good faith defense because of lack of awareness on part of conspirators at time they commit prohibited acts that they are in fact violating constitutional rights. It is United States versus Ehrlichman. It's E-H-R-L-I-C-H-M-A-N, 546 Federal 2nd District, 910. So they don't even have a good faith defense because they didn't know they were violating constitutional rights. If the right was violated, there's no good faith defense, period. Right or privilege to be guarded by predecessor to Title 18 U.S.C. Section 241, punishing conspiracy to injure any citizen in free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, is definite personal one, capable of enforcement by court, and not political, non-judicial one. Common to all, that public shall be protected against harmful acts. U.S. versus Bathgate, 246 U.S. 220, and a jury found that offenders violated Title 18 U.S.C. Section 241. Although offenders were not state officials, offenders were not entitled to a judgment of acquittal under federal Rules Criminal Procedure 29A because offenders engaged in conspiracy with police to deprive victim of his Fourth Amendment rights, and offenders were willing and knowing participants in conspiracy to conduct illegal search and seizure on victim. See U.S. versus Aponte Sobrado, that's A-P-O-N-T-E hyphen, that's a little dash, Sobrado, S-O-B-R-A-D-O, 847 Federal 2nd District, 316. Now, conviction under Title 18 U.S.C. Section 241, and what we're talking about is a federal criminal indictment. That's what 241 is, the federal criminal indictment. Requires that offender acted with specific intent to interfere with federal rights in question. This requirement does not mean offender must have been subjectively aware that his actions was unlawful, but rather it is sufficient that he performed acts intentionally, which, under circumstances of case, would have been clearly in violation of federal law, absent any other defense. That is United States versus Barker, 546, Federal 2nd District, 940. The California Invasion of Privacy Act is designed, right, to allow law enforcement to supersede your right of privacy, okay? And the right of privacy is enforceable in court. It is a personal one, common to all, okay? Now, indictment under Title 18 U.S.C. Section 241 need not allege specific intent to deny victim a benefit of particular federal right. United States versus Walker, 216 Federal 2nd District, 683, and need not allege intent in specific words, but can allege specific facts to show intent. United States versus Purvis, Purvis, 580 Federal 2nd District, 853. And where proof of conspiracy is established, relatively slight amount of evidence connecting offender therewith is sufficient to sustain verdict of guilty. Luteran, Luteran versus U.S., 93 Federal 2nd District, 395. Okay? Basically, if you had something like this done and it was documented in police reports or probable cause report, there's proof you need to show that is intent to violate your constitutional rights. Okay? Art of war. Your enemy's weapon can become your weapon. Although states' action need be neither exclusive nor direct, Title 18 United States Code Section 241 was applicable only to extent that 14th Amendment rights were violated or planned to be violated by wrongs done partly as a result of state action coming into play. United States versus Guest, 383 U.S. 745. On a side note, U.S. versus Guest establishes that you have the constitutional right to travel from state to state free from any encumbrance. Okay, you don't need a driver's license. Toss it. Indeed, the sweep of 18 U.S.C. Section 241 is not confined to rights expressly defined in Constitution, but includes those rights judicially determined to be fundamental and embraced by implication within Equal Protection Clause of 14th Amendment. United States versus Anderson, 481 Federal 2nd District, 685. Furthermore, the predecessor to 18 U.S.C. Section 241 did not require actions under color of state law. United States versus Powell, 212 212 U.S. 564. As the predecessor to Title 18 U.S.C. Section 241 dealt with free exercise of right or privilege secured by Constitution or laws of the United States, as such section extend to no rights other than those specifically spelled out in those terms, and therefore to no right or privilege dependent on laws or law or laws of state. United States versus Waddell, Waddell, 112 U.S. 76. Basically, that means you supersede, the Constitution supersedes state laws. Precedent herein shows that when a law enforcement officer provokes a pretext call, he is in fact inducing in the mind of the conspirator an agreement to conspire against rights secured by the Constitution or laws of the United States, and it is immaterial whether such conspiratorial action are known to be violative of those rights. This means original intent lies in the mind of the officer of the law who suggested to the victim to commit the crime of conspiracy against rights in a legal and unjust scheme that fosters rather than prevents and detects crimes, thereby constituting a criminal offense under Title 18 United States Code Section 241, whereby the non-state official conspirator is not entitled to judgment of acquittal under Federal Rules of Criminal Procedure 29A for engaging in the conspiracy with a police officer. Under the rationale of People v. Benford Supra, submission of the issue to the jury cannot be justified on the ground that it goes to the guilt or innocence of the offender. The crucial issue is whether the court or the jury can best achieve the purpose of preventing entrapment, the deterrence of impermissible police conduct. See People v. Moran. Only the court, through gradual evolution of explicit standards and accumulated precedents, can do this with a degree of certainty that wise administration of criminal justice demands. Sherman v. United States. See also People v. Moran. Thus, the trial court determines the admissibility of confessions and other evidence claimed to have been illegally obtained. People v. It's either Gorg or George. G-O-R-G, no E. 4-5 California State District 776 at 780 through 781. Penal Code Section 1538.5 Subdivision C. Evidence Code Section 405. See also People v. Moran. Okay, and that's the end of that memorandum. Okay, we're back. Had to change the battery. Okay, so that last memorandum that I wrote all these memoranda. I did all the research myself. I constructed the syntax, everything. I did all that myself. But the last memorandum, the gist of it is, right? In my case, my cousin Amanda Garrett did the pretext call at the behest of the Butte County Sheriff's Office, right? Now, what this does is it is a criminal offense because it violates the constitutional rights. 4th Amendment, 5th Amendment, 14th Amendment, etc., right? And under Title 18 United States Code Section 241, this becomes a criminal offense, okay? Which means Butte County Sheriff's Office and my cousin Amanda were committing a crime when they violated my constitutional rights. But because the original intent lies in the mind of Butte County Sheriff's Office, right, to do all this, to engage in such an endeavor with my cousin Amanda, they made my cousin Amanda a criminal. You understand? Now, that's where entrapment gets involved, okay? They entrapped her. Okay? Entrapment is a defense. When the police engage in criminal activity with a private citizen, right? Entrapment is a defense for the criminal action brought against the private citizen, okay? So, Amanda, when she gets indicted, can claim the defense of entrapment because the whole endeavor was criminal. And the whole endeavor originated in the mind of the Butte County Sheriff's Office, okay? I don't get the defense of entrapment. Amanda does. That's where a lot of attorneys fuck up with this, trying to use entrapment to argue against pretext calls. What fucking idiots. Okay, so this next memorandum. Defendant's memorandum regarding the poisoned pond, Amanda, and the soiled queen, Judge Christine Lucena. If you know chess, you'll recognize those as chess moves, the names of chess moves, all right? So the Equal Protection Clause of the 14th Amendment speaks to the states or to those acting under the color of a state's authority. It states in part that no state shall deny to any person within its jurisdiction equal protection of the laws. United States versus Guest, 383 U.S. 745. A state's authority is delegated by the U.S. Constitution and the laws of the state. Therefore, those acting under the color of a state's authority are acting under the color of law. To act under the color of law does not require that the empowered be an officer of the state. It is enough that he is a willful participant in joint activity with the state or its agents. That's United States versus Price, 383 U.S. 787. The Equal Protection Clause, combined with the personal right of privacy, reads thus: no state or any person acting under color of law shall deny to any person within its jurisdiction the equal right to freely exercise their personal right of privacy. True or false? If you said false, take a hike. Because the right of privacy is a subjective right, the Equal Protection Clause commands that every individual U.S. citizen has the equal right to expand or restrict their personal sphere of privacy to include or exclude any other person when, where, and as they freely choose. The act of eavesdropping is to secretly listen to a private communication, and inherent and intentional warrantless eavesdropping by a state or a person acting under color of law is the willful avoidance of a known legal duty resulting in the deprivation of and infringement upon the individual right of privacy secured by the U.S. Constitution and laws of the United States. Of course, that's without a warrant, that's warrantless. It is therefore impossible for the eavesdropper to intend the individual sphere of privacy remain pure and intact. When state agents direct a private person, person A, to engage in a particular action originating with the creative activity of the state agent, and person A is a willing participant in that state action, person A is acting under color of law at the exact moment of agreement. So earlier I said Amanda would be a private citizen. Now she's a state agent. At the exact moment of agreement which precedes the commencement of the state action itself. It is a commonplace that rights under the Equal Protection Clause itself arise only where there has been involvement of the state or of one acting under color of its authority. The Equal Protection Clause does not add anything to the rights which one citizen has under the Constitution against another, which means your right of privacy, okay, cannot be shared by somebody else. It doesn't belong to them. It belongs to you, okay? Just like I'm a complete stranger. I can't come into your house and then throw a party. That's not, and kick you out. That ain't my right. I don't have that right. Nobody has that right. You understand? Nobody has the right to share your personal privacy without your exclusive, freely exercised consent. Nobody. Anybody says otherwise is a goddamn dictator and a traitor to the Constitution. The act of eavesdropping, oh, I already read that part. When state agents, it is a commonplace, blah, 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 state. Okay, so so let me reread that paragraph. It is a commonplace that rights under the Equal Protection Clause itself arise only where there has been involvement of the state or of one acting under the color of its authority. The Equal Protection Clause does not add anything to the rights which one citizen has under the Constitution against another. United States versus Crookshanks, 92 U.S. 542. Criksshank, Crookshank. In a variety of situations, the court has found state action of a nature sufficient to create rights under the Equal Protection Clause, even though the participation of the state was peripheral, or its action was only one of several cooperative forces leading to the constitutional violation. Okay. Now look, if your state has a one-party consent rule, that law is null and void of law and bears no obligation to obey under Marbury versus Madison because it violates the Equal Protection Clause. You understand? What that law says is that, okay, your personal right of privacy can now be shared with somebody else, which is saying that you don't have the personal right of privacy. It is now a collective right of privacy. Wrong. As a void law. Ignore it. 100%. Protection clause. Okay, so here's the case law for what I just read. Shelley versus Kramer, Kraemer, 334 U.S. 1. Pennsylvania versus Board of Trusts, 353 U.S. 230. Burton versus Wilmington Parking Authority, 365 U.S. 715. Peterson versus City of Greenville, 373 U.S. 244. Lombard versus Louisiana, 373 U.S. 267. Griffin versus Maryland, 378 U.S. 130. Robinson versus Florida, 378 U.S. 153. Evans versus Newton, 382 U.S. 296. And you can find that in United States versus Guest. As guest. Like I'm a house guest. Violations under Title 18 United States Code Section 241, Title 42 USC Section 1985 subsection 3, Title 18 USC Section 2510 et sec, Title 3, and the 4th and 5th Amendments is established when person A, acting under color of law, knowingly and warrantlessly partners with one or more persons to deprive another of the opportunity to freely and consensually exercise their right to expand or restrict their personal sphere of privacy. Thus, the actions of the conspirators cause injury to the free enjoyment and exercise of the 4th and 14th Amendment rights and privileges and the laws of the United States belonging to the aggrieved person unaware of the conspiracy to include a secret, non-party eavesdropper in an otherwise subjective, confidential wired communication. You might have to play it back. The private person A jointly engaged with state officials and thus acting under the color of law has the legal duty under the Constitution to protect and enforce the Equal Protection Clause like any other state or state agent. And in Burton versus Wilmington Parking Authority, the court held that there is state action whenever the state has so far insinuated itself into a position of interdependence with the otherwise private person whose conduct is said to violate the 14th Amendment, that it must be recognized as a joint participant in the challenged activity, which on that account cannot be considered to have been so purely private as to fall without the scope of the 14th Amendment. You can find 365 U.S. at 725 Supra. Pennsylvania versus Board of Trust, Supra. Evans versus Newton, Supra. Peterson versus City of Greenville, Supra. Lombard versus Louisiana, Supra. Robinson versus Florida, Supra. Griffin versus Maryland, Supra. American Communications Association versus Dowds, D-O-U-D-S, 339 U.S. 382 at 401. Public Utilities Commission, I believe, versus Pollock, 343 U.S. 451. Smith versus Allwright, A-L-L-W-R-I-G-H-T, 321 U.S. 649. Terry versus Adams, 345 U.S. 461. Williams II, 341 U.S. at 99 through 100. And that's in United States versus Price. All that's United States Supreme Court case law. Otherwise, constitutional law, federal law. The foregoing establishes that when a private person acting under color of law utilizes a one-party consent statutory provision to engage in a warrantless eavesdrop and intercept of a subjective confidential communication with peripheral state agents, constitutional violations occur, as it is not the result of private action. By nature, reason, and the above precedent, a private person acting under color of state authority is for all intents and purposes an agent empowered by the state, a state agent, for the purpose of carrying out state action. Because a state is not authorized, nor can it authorize others, to violate constitutional rights outside the very limited exceptions, a private person acting under color of law is not authorized to violate the constitutional rights of another U.S. citizen, and as a manifestation of the state cannot deny equal protection of the law, nor arbitrarily invade the individual privacy of a citizen on behalf of the state, and must therefore be held to the same constitutional obligations as a state and its agents, as the private person is no longer private, but a government agent. Ignorance of the law is not an excuse. It is for these reasons that the state cannot claim activity was one of private action, for it was nothing less than absolute state action. And in this way, a private person acting under color of state authority cannot jointly collaborate with state agents and avoid constitutional violations when conducting a warrantless pretext phone call. In contrast, a private person at all times acting alone and according to the creative activity originating in their very own mind does no harm to the Equal Protection Clause and other constitutional rights, and this is reflected in Peterson versus City of Greenville. Private conduct abridging individual rights does no violence to the Equal Protection Clause unless to some significant extent state in any of its manifestations has been found to have become involved in it. See also Burton versus Wilmington Parking Authority. Again, nobody has the right to share your privacy. Marbury versus Madison. As shown in the attached herein and incorporated by reference, defendant's memorandum regarding judicial constitutional obligations. This is the last one we read. The violation under Title 18 U.S.C. Section 241 in the case at bar is not dependent upon whether or not state action was known to be violative of defendant Wilde's constitutional rights. Therefore, for the reasons discussed herein, Amanda Carol Garrett, the private person acting jointly with the Butte County Sheriff's Office, agents, acting under color of law, violated defendant Wilde's constitutional rights under color of law. To wit, the warrantless eavesdropping upon an interception of defendant's subjective, confidential, wired communication in a method commonly called a pretext phone call. Further violations by the conspirators, Amanda Garrett and Butte County Sheriff's Office agents, fall within the scope of Title 42 United States Code Section 1985 subsection 3 and Title 18 United States Code Section 2510 et sec. Title 3. Violations occurred under Title 3 Sections 2515, 2516 subsection 2, 2517, 2518 subsections 1, 3, 4, 5, 7, 8, 9, 10, and 11, and 2519, but are not limited to those sections of the chapter. Under Title 3, Section 2520D, as in dog, there is no good faith defense, and for statutory authorization in Title 3, Section 2520D1, CD attached here and incorporated by reference defendant's memorandum regarding right of privacy violated, which discusses the statutory construction of the California Invasion of Privacy Act. This California Penal Code, Section 630 et sec. As pertains to Section 633 of the California Invasion of Privacy Act, the court found in April 24, 1996, People v. Chavez, 44 California Appeals, 4th 1144 case, that the trial court construed the first paragraph of Penal Code Section 633 to mean law enforcement agencies are prohibited from engaging in electronic eavesdropping or recording activity if they were prohibited from doing so prior to the effective date of the chapter, November 8th, 1967. So the important thing to remember is there's two issues here, okay? One, they're saying that 633 says there's exemptions. It doesn't even say that. And the other one is that, okay, if there's a prohibition in effect before the effective date of the chapter, November 8, 1967, then law enforcement is bound by that. However, the third issue is the act itself requires that they get the consent of all parties to the communication, okay? So the prohibition, if you don't have all consent of all parties, that's the prohibition, and that's the act itself. The trial court to continue the quote, the trial court correctly determined that prior to November 8, 1967, neither federal constitutional law nor state law on electronic eavesdropping prohibited law enforcement, or federal constitutional law prohibited such endeavors only if there was a physical intrusion or trespass. And that was Olmstead versus United States, 394 U.S. 438. Katz versus United States overturned the trespass doctrine enunciated in Olmstead. It says there doesn't need to be physical presence. You can do it from a distance and still violate. Katz versus United States, 389 U.S. 347, and Kaiser versus New York. That's K-A-I-S-E-R, 394 U.S. 280. Simply for our purposes of analysis, we will assume the trial court correctly interpreted Penal Code Section 633 as holding law enforcement to the electronic surveillance prohibitions enforced prior to November 8, 1967, effective date of the Invasion of Privacy chapter. As noted, the trial court found one of these prohibitions to be Title 47, United States Code, annotated Section 605. Unlike the Chavez case, the applicability of Section 605 to the case at bar is not an issue here unless the reviewing fact finder finds it applicable. Instead, a pre-1967 case, Osborne versus United States, December 12, 1966, 385 U.S. 323, this U.S. Supreme Court case that was decided and became law and became controlling in December 12, 1966, about over a year before November 8th, about a year before November 8th, 1967. Now this has electronic surveillance prohibitions enforced prior to the November 8, 1967 effective date of the Privacy Act, which was not discussed in the Chavez case, but is relevant in the case at bar. In Osborne, a tape made to provide an accurate record of a conversation and sanctioned by judicial authorities was constitutional. The use of a recording device here under the procedure of antecedent justification before a magistrate that is central to the Fourth Amendment as the core of the Fourth Amendment as a precondition to lawful electronic surveillance was permissible, and the recording itself was properly admitted in evidence. And After considering this affidavit, the judges agreed to authorize a recorder in order to determine from recordings of conversations whether the statements in the affidavit were true. So it was that in response to a detailed factual affidavit alleging the commission of a specific criminal offense, the judges of that court jointly authorized the use of a recording device for the narrow and particularized purpose of ascertaining the truth of the affidavit's allegations. As the district judges recognized, it was imperative to determine whether the integrity of their court was being undermined, and highly undesirable that this determination should hinge on the inconclusive outcome of a testimonial contest between the only two people in the world who knew the truth. There could hardly be a clearer example of the procedure of antecedent justification before a magistrate that is central to the Fourth Amendment as a precondition of lawful electronic surveillance. What happens when you take the core out of something, cameraman?
Take the core out of something.
Yeah, what happens when you take the core out of something?
Well, it usually loses all structure and frame and collapses.
Oh shit. Oh shit. Is that what they're doing? Did they just collapse the Fourth Amendment with their criminal actions? For shame. Footnote 9 reads, the requirements of the Fourth Amendment are not inflexible or obtusely unyielding to the legitimate needs of law enforcement. It is at least clear that the procedure of antecedent justification before a magistrate that is central to the Fourth Amendment, Ohio ex rel. Eaton versus Price, 364 U.S. 263-272, separate opinion. C. McDonald versus United States, 335 U.S. 451 and 455, and Abel, A-B-E-L, versus United States, 362 U.S. 217 and 251 through 252, dissenting opinion, could be made a precondition of lawful electronic surveillance. This is Lopez versus United States, 373 U.S. at 464, dissenting opinion of Mr. Justice Brennan. Footnote 7 echoes, in 1966, the legislative intent declared in California Penal Code, section 630, and says, I also share the opinion of Mr. Justice Brennan that the fantastic advances in the field of electronic communication constitute a great danger to the privacy of the individual. That indiscriminate use of such devices in law enforcement raises grave constitutional questions under the Fourth and Fifth Amendments. Agreed. In the Osborne case, Mr. Justice Brennan, in a dissenting opinion, said, it is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. It is the invasion of this sacred right which underlies and constitutes the essence of Lord Camden's judgment. That's European law, right? Magna Carta. Intic, that's E-N-T-I-C-K, versus Carrington, C-A-R-R-I-N-G-T-O-N, 19 H-O-W period S-T period T-R period 1029. I didn't actually read that one, but whatever. Breaking into a house and opening boxes and drawers are circumstances of aggravation, but any forcible and compulsory extortion of a man's own testimony to be used as evidence to convict him of crime is within the condemnation of that judgment. In this regard, the Fourth and Fifth Amendments run almost into each other. Boyd versus United States, 116 U.S. 616 at 630. As already indicated, Boyd versus United States Supra made it clear that if the barriers erected by the Fourth Amendment were not strictly honored, serious invasions of the Fifth Amendment might result. Encouraging a person to talk into a concealed bug may not, that's electronic bug, may not be compulsion within the meaning of the Fifth Amendment, but allowing the transcript to be used as evidence against the accused is using the force and power of the law to make a man talk against his will. Illegitimate and unconstitutional practices get their first footing by silent approaches and slight deviations from legal modes of procedure, as Boyd Supra. Now, a transcript was used in the case at bar. Okay, a summary of the intercepted communication was included in the probable cause report. Here's how it went down, right? February 3rd, I went back to Washington as per my travel permit. Okay, I got up there on February 4th. I got arrested for a probation violation. I didn't actually get arrested. I just got detained or whatever. It's not. I had no Miranda rights read to me by my probation officer. Okay, it's not common practice when they're just violating you. Okay, and on February 6th, okay, while I'm being detained, serving time for a probation violation, Butte County Sheriff's Office presented a probable cause report to Butte County judge to ask for a Ramey arrest warrant. Okay, and in that probable cause report was a summary of my words. You tell me. It's a violation of the Fifth Amendment all day long. It wasn't until the 24th I got Mirandized. Okay? Fuck. I didn't even have a cop say it. They just put a video on in the lobby of the jail where I got transferred to, and you know, the judge sitting there Mirandizing. In the Osborne case, a person was judicially authorized to conceal a recording device upon their person in order to record verbal evidence supporting an allegation of crime. Osborne's voice created sound waves in the air, which the particular recording device, or bug, was designed to seize from the air itself, and it is in this scientific and technological fashion that the verbal evidence was intended to be seized for later use as evidence in court under the preceding judicial authorization. Seizing the sound waves created by Osborne's voice is very different from seizing the radio portion of a cordless phone, as can be distinguished in People versus Chavez, or attaching a device directly to the telephone transmission line, as in Olmstead versus United States. Because the courts have established the type and method of eavesdropping and interception can be distinguished by such scientific subtleties as radio waves, electric transmission, and, in Osborne, sound waves, it is appropriate to adopt the conclusion that in Osborne, sound waves were constitutionally protected under the Fourth Amendment, and this conclusion is supported by the bugging method used therein. An example, a recording device concealed on a person which intercepts sound waves. The device used was not intended to be attached to a transmission line nor attached to Osborne himself. It was not intended to intercept radio waves. This means the sound waves themselves and not their point of origin, example, Osborne's throat, tongue, and lungs, but the pressure variances in the air itself was intended for seizure. When sound is emitted from a person or a speaker, like a radio speaker or something, whether it is the speaker in a radio or a telephone with its speakerphone function activated, the result is the exact same thing. Pressure variances are created in the air itself, called sound waves. See appendix for the science of sound waves. This means that any device that is used to intercept sound waves from the air itself and not its origin source was prohibited from use without judicial authorization in 1966. And this is evidenced by the contrasting view in Osborne that a tape made to provide an accurate record of a conversation and not sanctioned by judicial authorities was unconstitutional. The use of a recording device here not under the procedure of antecedent justification before a magistrate that is central to the Fourth Amendment as a precondition of lawful electronic surveillance was impermissible, and the recording itself was improperly admitted in evidence. By extension, the transcripts. The Osborne case established that warrantless interception of sound waves violates the Fourth Amendment, and this is therefore a prohibition in force in 1966 prior to November 8th, 1967, the effective date of the California Invasion of Privacy Act, and is thus an unlawful method under California Code Section 630 et sec. Decided by the U.S. Supreme Court, it falls within federal constitutional law. This then contemplates that the Osborne case, and not the December 1967 Katz versus United States Super case, overturns the trespass doctrine enunciated in Olmstead versus United States and Goldman versus United States 316 U.S. 129. If this had been the case, as it should be, federal constitutional law would prohibit non-physical intrusion and trespass in 1966 and not December 1967. This may have influenced a different outcome in People versus Chavez and other like cases. Because the sound wave seizure method is a prohibition in force prior to the effective date of the Privacy Act and was the same seizure method used in the case at bar, Defendant Wilde's constitutional rights were violated prior to the issuance of any arrest warrant and prior to the filing of the felony complaint and prior to Washington State extradition proceedings and issuance of a governor's warrant. I took that shit to the governor's office. When Amanda Garrett, described herein, acting under color of law, called Defendant Wilde, she was in a room in the Butte County Sheriff's Office with Butte County Sheriff's Office agents, Detective Jason Miller, and I believe it was Sergeant McNellis. Garrett activated her cell phone speakerphone function so Defendant Wilde's voice would be amplified and carried to all corners of the room. Meanwhile, Butte County Sheriff's Office agents placed a recording device near the phone and was not attached to it in any way. This device was intended to intercept the sound waves from the air during the course of the conversation between Garrett and Defendant Wilde. This device was used outside of the procedure of antecedent justification before a judge that is central to the Fourth Amendment as a precondition of lawful electronic surveillance. See also Osborne versus United States, December 12, 1966, 385 U.S. 323. The unconstitutionality in the case at bar is clearly unambiguous, and a violative state action or actions fall within the scope of violating Title 18 United States Code Section 241, Title 18 United States Code Section 2510 et sec, Title 42 U.S.C. Section 1985 subsection 3, California Penal Code Section 630 et sec, and the 4th, 5th, and 14th Amendments of the United States Constitution. Proof of these violations can be found in the case at bar's police report, probable cause report, discovery, and court records for California and Washington states, and the Department of Justice and the Governor's offices of California and Washington state as pertains to Governor's warrant. It is for the foregoing reasons and those discussed in incorporated documents and communications to the court by the defendant that a sua sponte dismissal should be entered by the reviewing fact finder. It is a fact that the recording device used in the case at bar constitutes a concealed bug due to its secret use. Alright. Now there's one more thing I wanted to read to you guys. I filed a motion for dismissal too. So that I got a little glare here on the phone from the sun, but so motion to dismiss regarding Butte County Superior Court has no jurisdiction over defendant due to government criminal action or actions and constitutional violation or violations. They lost jurisdiction the moment they conducted the pretext call, because then it became a crime. Everything after that, and whenever they collect evidence while committing a crime and include it in something else, it taints everything and becomes fruits of the poisonous tree, which means all arrest warrants, all filing complaints, all governor's warrants, fruits of the poisonous tree. They lost jurisdiction. So, Kyle Wilde, defendant in Butte County Superior Court, hereby moves the court. Kyle Wilde, defendant in Butte County Superior Court, cause number 20 CF 01073, hereby moves the court to dismiss cause number 20 CF 01073 and states the following reason or reasons. In regards to the pretext call conducted in my case under Penal Code Section 630 et sec, the general rule of thought is law enforcement are only prohibited from electronic eavesdropping intercept by any law in effect prior to the effective date of the California Invasion of Privacy Act, November 8, 1967. In the defendant's memorandum regarding the poisoned pond and the soil queen, which we just read, the defendant points out that there is a prohibited eavesdropping intercept method in force in 1966 prior to the effective date of the California Invasion of Privacy Act, Penal Code Section 630 et sec. Pursuant to the U.S. Supreme Court under Osborne v. United States 385 U.S. 324, a recording device used and designed to intercept sound waves was considered constitutional with judicial authority. In contrast, without judicial authority, its use, and particularly the sound wave intercept method, would be unconstitutional and violate the Fourth Amendment. Defendant alleges the method used to conduct the pretext call in the case at bar was to intercept the sound waves emanating from Amanda Garrett's Butte County Sheriff Office reporting party speakerphone with a device designed to intercept sound waves. As there was no judicial authority for such conduct, my Fourth Amendment rights were violated. Under Osborne Supra. As such, this constitutional violation constitutes criminal action pursuant to Title 18 United States Code Section 241. Because of the criminal conduct committed by Butte County Sheriff's Office and Amanda Garrett, entrapment has occurred. As Butte County Sheriff's Office's criminal endeavor under Title 18 United States Code Section 241 makes a criminal and a conspirator of Amanda Garrett, as defined by Title 18 United States Code Section 241. As a result of this criminal enterprise, Butte County lost any jurisdictional rights over defendant and falsely imprisoned defendant in two states, Washington and California, and illegally extradited defendant from Thurston County, Washington to Butte County, California. You do not have any claim to take me to trial. To avoid any retroactive repercussions in other cases that had similar methods used during a pretext call, it is highly recommended that you honor your oath to defend the federal Constitution. I have advised my attorney, Eric Ortner, Butte County District Attorney Mike Ramsey, and Deputy District Attorney Jeff Greason of this matter. I look forward to your honorable response to this grave matter that threatens to undermine the Constitution of the United States of America. Thank you. Have a good day. So I sent a similar thing to Butte County District Attorney Mike Ramsey and to Jeff Greason, who is lead prosecutor on my case. So the next thing I want to read to you I title it Murdoch versus Pennsylvania. C. Murdoch versus Pennsylvania, 319 U.S. 105, which says no state government may convert a constitutional right into a privilege and impose a license tax and/or fee upon it. The court said no one should have to pay a license tax to exercise constitutional rights. Then see U.S. versus Guest, 383 U.S. 745, which states that the people have the constitutional right to travel freely from state to state, free from any encumbrance that would inhibit or prohibit such travel, and to use highways and other instrumentalities for that purpose. These are just examples of what America stands for. Driving without a license comes with punishment, paying a fee to enjoy the Second Amendment, and many more rights that have been converted to privilege and slapped with a fee or tax, which, if not paid, is then withheld from you. Trump has no idea how to make America great again. No, America will not be great under any president until the dictatorship woven into the laws is removed and the power and freedom of the Constitution restored. Contract law holds that when one party breaches the condition or conditions of the contract, the penalty clause is invoked and the contract becomes void when one party engages in criminal activity. What happens when any state government violates the constitutional rights of the U.S. citizen? They are in breach of the contract, the supremacy contract of the U.S. Constitution, which grants that state authority to govern with the condition that the rights it guarantees will not be abridged by the government outside of a constitutionally legal course of action. Title 18 United States Code Section 241 makes it a criminal offense to violate the constitutional right of the U.S. citizen, and associated case laws have held that the violator or violators need not know that they were violating those rights, and that it is sufficient that the right was violated, period. So if a state government violated the constitutional right of a U.S. citizen without knowing they did, they committed a crime under Title 18 U.S.C. Section 241, breaching the contract clause of the U.S. Constitution, therefore voiding all delegated powers granted by the Constitution to the state under U.S. contract laws. Question: how many states have violated the constitutional rights of U.S. citizens? The conclusion here is that no state has any authority to govern, as they have all voided the constitutional contract. No state election is valid. No governor is legally sitting in office. No state office is supported by the federal Constitution. All state law enforcement officers are illegal. The United States of America ceased to exist long ago under its own laws. It's time to make America great again. How many laws are void under this line of reasoning pursuant to Marbury versus Madison, 5 U.S. 1 Cranch 137, and Norton versus Shelby County, 118 U.S. 425? These cases say in short, a law or statute that abridges the federal constitutional rights of a U.S. citizen is repugnant to the federal Constitution. Therefore, it is null and void of law from the date of its inception, and it requires no obligation to obey. Let me ask you, do criminals make laws? Is usurped power legal? If a law is made by the usurper, does it not automatically become repugnant to the federal Constitution on the day of its inception? It is noteworthy that Monell versus Department of Social Services, 436 U.S. 658, removes qualified immunity from government when constitutional rights are violated and allows government to be sued for abridged rights. See also Owen versus City of Independence, 445 U.S. 622, and Maine versus Thibodeau, 448 U.S. 1. Here's how it works. When a federal civil court in a suit brought under Title 42 United States Code Section 1983 finds in favor of the citizen and holds the government or one of its manifestations violated federal constitutional rights, then you have confirmation that can then be used in an indictment, a criminal indictment, under Title 18 U.S.C. Section 241, which is then a guaranteed win for the plaintiff, the citizen, in the federal courts. Once your Section 241 case is won, you now have two federal court rulings, civil and criminal, that held the government and its manifestations violated the federal constitutional right or rights of the U.S. citizen. This constitutes proof of a breach of the Constitution contract clause committed by the state, and the Attorney General could be forced to utilize a little-known writ called quo warranto. The legal dictionary defines quo warranto in part as, in some quo warranto proceedings, the issue is whether the defendant is entitled, that'd be the government, is entitled to hold the office he claims or to exercise the authority he presumes to have from the government. In addition, proceedings have challenged the right to the position of county commissioner, treasurer, school board member, district attorney, judge, or tax commissioner. In certain jurisdictions, quo warranto is a proper proceeding to challenge individuals who are acting as officers or directors of business corporations. Now, a county is granted governmental authority through its charter and the state constitution, and that conditional authority flows from the federal constitution. For purposes of quo warranto, a county is legally defined as a person, and a municipal corporation, ergo a county, is liable for suit under Title 42 United States Code Section 1983 and indictment under Title 18 United States Code Section 241. The county is under contract not to violate or otherwise abridge the constitutional rights of a U.S. citizen within its jurisdiction outside constitutional exceptions. Therefore, when it does breach that contract, the contract is automatically voided under U.S. contract laws due to the criminal action held by federal court under Section 241 and by the civil action held under Section 1983. Therefore, the guilty county no longer has governmental authority. The county does not in fact exist under the law. So, quo warranto is used to ask the county, by what authority? Once again, I ask how many counties have violated the constitutional rights of the U.S. citizen and how many states. Each state has no governmental integer, which means it is a substanceless entity, and all non-federal government manifestations are without constitutional authority. They do not exist in law, and their continued assertion of power is a crime in itself. Therefore, each state and its integers are by definition ratifying anarchy. Just think about all the state and county and all the respective derivatives, owned property, monies, and assets, etc., that will be forfeited. What should be remembered are the retroactive repercussions to constitutional violations. When these violations occur but go unnoticed, both criminal and civil cases will need to be revisited once the violations come to light. For example, when the sheriff's office violates the constitutional rights of the U.S. citizen during a criminal investigation, and that violation goes unnoticed only to be brought to light in a later case, then all cases in which that violation occurred and went unnoticed shall be revisited, as the Constitution demands its superiority and purity remain intact and untainted. This means that past cases may be retried or dismissed entirely. Yet due to the civil and criminal judgments held by the federal courts against the state/county, each and every case against a U.S. citizen prosecuted by a manifestation of the government shall be dismissed due to the unconstitutional and therefore inherent criminal conduct of the government. Every case affected by such conduct is tainted in a manner the government was not constituted for. This would cause a mass release of inmates and litigation against their accusers. On a side note, go on Amazon, look up my book. I just published it. You spell it D as in dog, U-R-A-N-K-I, Duranki. Okay? Or you just type my name in, Kyle Wilde, W-I-L-D-E, into the search bar of Amazon. My book will pop up. In it, I prove the origins of man. In it, I prove the Bible is wrong. In it, I prove that the Bible actually talks about Sumerian gods, the Anunnaki, literally. I prove Atlantis. I prove Lemuria. I also prove that the tablets of Thoth are real. Okay? I rewrite history. I rewrite history. I dare anybody out there to try to refute me. I dare you. You won't be able to do it. Garthian explorations, baby. Freelance archaeologist, researcher, and explorer. Fuck with me.